many of the restrictions that places like New York and California intend to and are applying to people that want to be able to conceal carry handguns are likely unconstitutional under the standards set forth in NYSERPA versus Bruen. Let me explain why when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. All right, folks, I want to cut to the chase here. Many of the laws that are being promulgated by places like New York and California to make it harder to carry guns and to get your permit are unconstitutional under the Supreme Court's precedent of NYSERPA versus Bruen. And I want to make sure that everyone's arguing this correctly. And I want to point out to the key language that you all can use as appropriate yourselves. Let's step back for a second. What was NYSERPA versus Bruen about? NYSERPA versus Bruen arose from a challenge of two individuals in the state of New York that wanted to be able to carry guns for self-defense, generally speaking. The state of New York viewed that the right to carry guns in public was not a right, but was a privilege. They quickly changed their tune when they got to the Supreme Court, and they simply acknowledged, oh yeah, the right to carry guns is the right to bear arms. That is a protected right, but we get to regulate it. And then they try to regulate it. Well, the Supreme Court saw through this. What the Supreme Court said was this, that look, New York, you are using discretion, and this is the key word today, discretion. You are letting your government officials, your law enforcement agents, your judges, whomever they are, to exercise discretion, which means judgment, subjective judgment, as to who gets to carry guns and who doesn't. And specifically, up until NYSERPA versus Bruen, the discretion that the government of New York, places like California, used was the discretion whether or not you or I or others in those states needed to carry a gun. Did they have a good enough reason to carry a gun? Did they need to carry a gun for some special reason? Because they're famous, because they're at risk, because they're being stalked, whatever it is. The question was, could government engage in the discretionary decision to determine whether or not you needed to carry a gun in public? The Supreme Court says, no, that's not allowed, because you're not allowed to determine whether or not someone has a need to exercise a constitutional right. That's not how the Constitution works. For example, it would be absurd if you had to go to the government and beg for permission because you needed to go to Mass, because you needed to take communion, because you needed to post a comment about a political official online or write an op-ed, and that they would only let you do it if you needed to do it, and you could establish in the discretion and the eyes of the law enforcement officers that you needed to do so. That's absurd. That's not how the Constitution works, and that's exactly what the Supreme Court said. So in light of that victory in NYSERPA versus Bruen, where are the anti-gunners going in places like New York and California? Well, where they're going is they're still, and this is where they're going to get blown up legally, is they're still allowing their government officials and law enforcement officers to engage in discretion, except what they've done is a sleight of hand. So up until NYSERPA versus Bruen, the discretion was exercised in whether or not you needed to carry a gun. However, now they've shifted the discretion from do you need to carry a gun to exercising the discretion whether or not you are good enough to carry a gun. Meaning, do you have good moral character? So they are still going to use discretion. I'm going to tell you what they're going to do, and then I'm going to tell you why it's unconstitutional and why it's going to get struck down. But just to be clear, they've gone from using discretion to determine if you need a gun to now they're using discretion whether or not you're good enough to have a gun. You're good enough to be able to carry a gun. And they're using that by saying that we get to determine whether or not you and I and other Americans in New York or California are good enough to carry a gun, meaning do we have good moral character required to be able to carry a gun? And they say we want to engage in certain activities to determine whether or not you and I are good enough, have the good moral character and judgment to carry a gun. Now, the way they're doing it, and I'm going to tell you why it's all unconstitutional in a second, but what they're trying to do, for example, is they want to get personal recommendations from our neighbors and our friends and our family members. In certain places in New York, you need to get 4 letters of recommendation from people. Now, as to how someone who just moves to New York can get those recommendations when they don't know anyone in New York is a separate question. We'll talk about that in a separate video. But so what is the point of these 4 letters of recommendation? What are you going to glean from that? Likewise, they want you to turn over your social media accounts so they can presumably look at them. And they also want you to be personally interviewed by the police. So the question is, what is the purpose of a police officer, law enforcement agent, looking at these personal recommendations, looking at the outcome of the interview of you, looking at your social media accounts? What exactly is the purpose here? Well, the only possible purpose, and also, by the way, looking at like your mental health records beyond just a mere NICS background check to determine whether or not you've been civilly committed, which makes you a prohibited person under 18 U.S.C. 922G right now. So the only reason why these police officers and these states would want to look at these specific things is so they can exercise discretion, which is illegal, and you'll see why, discretion to determine whether or not you're good enough to carry a gun. So whenever you see references that I want personal recommendations, I want to meet you, I want to interview you, I want to look at your social media accounts, this is all, and I want to look at, any kind of medical records or whatnot. This is basically so police officers can exercise discretion and form an opinion about whether or not you're good enough to carry a gun. But it's not legal under NYSERPA versus Bruen. Let me give you an example. To begin with, in the Supreme Court decision itself, it specifically says that you're allowed, a state can require some sort of permit to be able to carry guns in public. That is okay if it shall issue, but the standard has to be, this is not my language, this is not your language, this is the Supreme Court. The standard has to be narrow, objective, and definite. Let me read that out loud again. This is what the Supreme Court says, that you can require shall issue permitting. A state can require you to get a permit if it shall issue, provided that the criteria is narrow, objective, and definite. Narrow, objective, and definite means, by definition, no discretion, no opinion judgments, nothing like that. Narrow, objective, definite. That's in the Supreme Court. That's in the Supreme Court decision itself. These things are not narrow, definite, or objective. They're just like, we're going to look at a bunch of stuff and make a determination. That's not narrow, it's not definite, and it's certainly not objective. Now, let's go on and see what else is in the Supreme Court opinion that demonstrates that what New York and California do is hooey and not going to work. Let's look at Justice Kavanaugh and Justice Roberts' concurrence, where they elaborate further. Now, here's a critical bit of the language. Write this down if you're in court or ever thinking about getting harassed if you're getting harassed by someone on this topic. This is what the Supreme Court wrote in the concurrence, Judge Kavanaugh. Ready? Very important language. New York's regime was, quote, ready? Constitutionally problematic because it grants open-ended discretion to licensing officials. I'm going to read that again. New York's regime was constitutionally problematic because it grants open-ended discretion to licensing officials and, critically important word, and, conjunctive, means both, and authorizes, this is Kavanaugh continuing, and authorizes licenses only for applicants who can show some special need apart from self-defense. This is a critical sentence in Justice Kavanaugh's concurrence, because he points out there's 2 problems with what New York was doing and why there's 2 problems that caused it to be unconstitutional. The first problem was that it gave open-ended discretion to licensing officials. Problem number 1 that made it unconstitutional. And problem number 2 that also made it unconstitutional was that it authorized licenses only for applicants who could show a special need. Do you see what happened there? What's going on now in places like New York and California is they're trying to give open-ended discretion to licensing officials to go from whether or not you need a gun to whether or not you're good enough to have a gun. But it's still the type of open-ended discretion to licensing officials that Justice Kavanaugh talked about in Bruen. That's why the New York situation was unconstitutional. What the anti-gunners are going to try to do, and the reason why I want to hammer this home so importantly, is the anti-gunners are trying to conflate, they're trying to blend, to bring together these two problems and say there was only one problem. What the anti-gunners are trying to argue in court and in legislation is to say, no. All the Supreme Court said was that we made a mistake under the Constitution by focusing on whether or not you needed to have a gun in public for self-defense. We're not going to do that anymore. But there is nothing wrong with making sure you have good moral character, and we are allowed to exercise discretion to determine whether or not you have good moral character by looking at all this other nonsense, your social media accounts, your postings, letters to the editor. What do your neighbors think of you? What does your family think of you? What does your employer think of you? What do we think of you when we interview you? That's all nonsense, because Brett Kavanaugh in Bruen specifically writes that the New York regime was constitutionally problematic because it grants open-ended discretion to licensing officials, period, full stop. Period, full stop. Open-ended discretion to licensing officials is unconstitutional in the context of shall issue permitting schemes. Period, full stop. All of this nonsense, and you watch what's going to happen in the federal courts, because I think this is all going to get blown up in New York and California. All this nonsense they're harassing you over to get this license is all basically given an excuse for police and law enforcement and licensing officials to exercise open-ended discretion. It is not going to fly in my view. It is going to get stopped. Moreover, slight digression, but it relates. Slight digression. Never forget the famous Supreme Court case. I believe the decision was in 1967, but it was in the 1960s, called Harper versus Board of Elections. Harper versus Board of Elections. You're like, Mark, why are we talking about Harper versus Board of Elections in the context of why New York's licensing regime and California's carry licensing regime in the modern context is unconstitutional? You see, Harper versus Board of Elections, the Supreme Court said that a poll tax of $1.50 was unconstitutional. Now, all of this mishigosh, nonsense, hoops they're making you jump through when it comes to getting these carry permits, to me, has the look and the feel of a poll tax that's unconstitutional under the Supreme Court's rules. And mind you, the NYSERPA versus Bruen, the Supreme Court flagged this possibility because in one of their footnotes, I forget the number now, but in one of their footnotes, they specifically said that they are going to be paying attention to licensing regimes that basically take too long or get abused or misused in some way. And I suspect that what New York and California is doing is essentially the sort of thing the Supreme Court says they were not going to tolerate going forward. So we will see. But let me also add one last thing, just to make sure that it's crystal clear that any kind of discretion on the part of licensing officials as to whether or not you are allowed to carry a gun in public to get that permit is a no-go verboten thing, is here's another thing from the Kavanaugh concurrence. Very important language, and then we'll wrap up. There's 43 states that were either permitless carry or shall issue at the time NYSERPA versus Bruen was decided. There were 6 states that were the bad states, New Jersey, New York, California, Hawaii, etc. You know who they are. Those were the may issue permitting states. Here's what Kavanaugh said about those 6 states that were the bad gun states. Quote, the 6 states, including New York, potentially affected by today's decision, may continue to require licenses for carrying handguns for self-defense. Okay, they can continue to require licenses. Here's the key. So long as the states employ objective licensing requirements like those used in the 43 shall issue states. Objective. So you see the trend here? The standard has to be objective, discrete, narrow, no discretion on the part of the licensing officials. Requiring people to produce all this other material is clearly asking for discretion to seep in to the question no longer of whether or not you need to carry a gun. That's been shut down undeniably. Now they're trying to say we get to exercise discretion as the government to determine whether or not you're good enough to carry a gun by virtue of determining whether or not you have good moral character. But that is not going to fly based upon the language I just gave you from NYSERPA versus Bruen, including from Brett Kavanaugh, specifically that made it clear that no discretion is allowed. If discretion seeps in and people get to make judgment calls whether or not you exercise a constitutional right, well, guess what? That's unconstitutional and will be struck down, in my opinion. Okay? Well, I hope you learned a little bit something. I know this is a little bit more of a geeky kind of speech or a little bit more of a geeky presentation, but some of these nuances are very, very important to understand so that the anti-gunners don't basically pull the wool over your eyes and they don't dupe judges and law clerks and others into doing what's violative of our constitutional right to keep and bear arms. So I want you really to understand this at the highest levels of intellectual experience because it's very important because we never want anyone to lose their right to keep and bear arms or any other constitutional rights, and giving you this detailed information hopefully will protect us all across the country. All right? Well, hope you learned something today. If you haven't subscribed to the Four Boxes Diner, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.